Okay. Welcome to another episode of QuickIP. And hello, today we're going to be talking about copyright acquisition and transfer, and that includes ownership. As usual, we start with the map, with our map of the various stops as it relates or as they relate to copyright law. So we've dealt with the first stop. We've passed the first stop, which is subsistence, where we spoke of the starting point, which is a work, and then the work has to be original, it has to be fixed in a material form, and the work has to be authored by a qualified person. And we've also talked about economic rights and moral rights, which are the two broad categories of rights that are conferred under copyright law. The next thing that we are dealing with, which we've touched on, is step two. We talked about authorship in relation to a given work. And we said that authorship is also equally important because it is linked to each work. So in relation to, say, a literary work, for example, the author is the person who created the work, the same thing with a musical work, the same thing with an artistic work. And then when we talk about sound recording, we talk about computer programs, talk about cinematography film, the author would be the person who made arrangements for the creation of that work. So that's that for authorship. And that's also something that is in addition to the fact of the author being a qualified person, say a citizen of the jurisdiction in which the work was created, or an entity, a company registered in the country in which the work was created, or if the work is published in a particular jurisdiction in which one is claiming copyright from. So we are now going to stop three, and we will also touch on step 4 as well. So step 3, we're talking about ownership. So we pause on this, let me call it bus stop for now. So when it comes to authorship, the key issue or the key position or rule is that the author is the owner of a given work. So I've already talked about authorship in relation to an artistic work, say a photograph. In relation to a photograph, it's the person who took the photograph. Sometimes it's the person who directed the taking of the photograph, depending on the jurisdiction. But let's talk about artistic work generally, as excluding photographs. Artistic works, it's the person who created the artistic work. Musical work, it's the person who created the musical work. Literary work, it's the person who created the work. So the person who wrote the book, the person who wrote the article, the person who wrote the blog post, and so on and so forth. Computer program is the person in South Africa, at least, is the person who made arrangements for the making of the computer program. In jurisdictions where computer programs are protected as literary work, then it would be the person who created the computer program. So, for example, the developer or the software developer, the developer. For sound recording, it's the person who made arrangements for the making of the sound recording. Now, that's the general rule. The author is the owner of copyrights in the work. So if it's the author of a book, it's the author of the book who is also the owner. The same thing with photographs, the same thing with what I've just said previously regarding who the author is. The author is always, or usually, not always, usually the owner of copyright in the work. Now, let's differentiate between authorship and ownership. When it comes to authorship, authorship relates to the making of the work. Ownership is actually the person who gets to exercise those rights that we've talked about, the economic rights, especially the moral rights, of course, is with the author, but the ownership of the economic rights resides in the owner of the work. And we're saying that the rule is that it's the author who is also the owner of the work and can exercise all those rights of ownership, except that there are four main exceptions to that rule. So in the cases where the exception applies, then the author will not be the owner of the work. They still remain the author of the work, because authorship is a factual issue. It's either you wrote the book or you did not write the book. It's either you wrote the music or you did not write the music. It's either you are the one who made arrangements for the making of the work or not. In respect to computer program, it's the person who made arrangements or the person who exercised control over the making of the work. In South Africa, it's the person who exercised control. That's the author of the computer program. Remember that we've said previously that South Africa, unlike some jurisdictions, provide for computer programs as a specific category of protectable subject matter. Now, let's talk about the exceptions to the author being the owner of the work. If a work has been made, a literary work, and if a literary work or a musical work has been made for purposes of publication in a journal, in a periodical, in a magazine, that kind of work, if the work is created for purposes of publication, then the proprietor of that newspaper or the magazine or the periodical is the owner of the work for purposes of the publication itself. So let's break it down. This particular slide that refers to Oloture, a Netflix movie, was something that generated a lot of debate, a lot of controversy, because this movie was said to be based on an investigative journalistic report written by someone called Tobore, an author, a journalist. So she was working with a newspaper at the time, and she wrote an investigative report as an employee of this newspaper. And so for purposes of publication in that newspaper, as an employee of that newspaper, the newspaper, of course, owned copyright in that investigative journalism. But now it's been made into a movie, and the controversy was around whether that she should have been the owner of copyright in that work for purposes of any other thing outside the publication, because that's what you have in the copyright law in Nigeria, which is similar to what you have in South Africa currently. But just know that for our own purposes and for purposes of QuickIP, which is just quick bites of knowledge, just know that the author is the owner in all cases except where it's a literary work or a musical work, and it was created for purposes of publication in a newspaper or magazine or periodical, journalistic publications. The second exception is where it's a commissioned work, and that relates to artistic work. So this photograph is a commission. It's from a photographer that takes commissioned family portraits, right? So when the work is made for purposes of commissioning, then the person who commissioned the making of that artistic work would be the owner and not the author, which is usually the person who took the photograph. So that's another exception. Another exception to the author being the owner of copyright in a work is a work created in the course of employment. If it's within the scope of your employment, then it is not you who created the work that would be the owner. It will be your employer. The fourth exception to the general rule of the author being the owner of copyright in a work is work created under the direction and control of the state. And this photograph here, or this picture here, is one that deals with the copyright in Uganda's national anthem. The court in Uganda, the Court of Appeal in Uganda, ended up to say that it is not the musician who wrote the musical composition for that made up the national anthem of Uganda that was the owner of copyright in national anthem, because the national anthem was he composed national anthem as part of a competition that was organized by the Ugandan government at the time. And so the court, on that basis, ruled that no, this is one of those times where the exception applies, and it is not the musician who is the owner of copyright in national anthem, but the state, because the state directed the making of that musical composition. There are debates around the basis upon which the court arrived at that decision and the way the court interpreted that the making under the control and direction of the state. But for our own purposes right now, we just need to know that works that are created under the direction and control of the state, it will not be the author who will be the owner of the copyright work. Instead, it will be the state. One thing to note is that parties may contract out of statute. So even though the statute has all these exceptions, parties can in their contract say the author will still be the owner, or someone else, a third party, will be the owner of copyright in the work. But just know that if parties do not contract out of statute, then the exception would apply. Let's quickly talk about acquisition and transfer of copyright. The same way, or let's not say exactly the same way, but copyright can be transferred or acquired similar to the way you acquire real property or tangible property. So it can be acquired by assignment, it can be acquired through a license or licenses, it can be acquired by testamentary disposition. So somebody can bequeath copyright in a work that they own to someone through a will or some other testamentary disposition. It could also apply by operation of law in cases, for example, where maybe the state has transfers copyright in a work to the public or to certain persons, or there's a law that says works that are created in specified circumstances would be transferred, ownership of that work will be transferred to a certain person. So those are the 4 key ways that copyright can be acquired or transferred, the same way or similar to how you would acquire or transfer tangible property. And this is where we stop for today. Quick run through. Remember that when it comes to authorship and ownership, there are 2 different things. The author is a factual situation where it is the person who created the work or made arrangements for the creating of the work. And that's the general rule. The author is also the owner and who can exercise rights and who can transfer or transmit that ownership to a third party. But there are exceptions to that rule that the author is the owner of the work. And those exceptions apply for works that are made or intended for publication in a magazine, newspaper, or periodical, works that are commissioned works, and the works that are made under the direction and control of the state. And also the third one is work that is made in the course of employment, so long as it is within the scope of employment of such person. This is where we stop, and thank you for listening, and see you in class.